Hello, everyone. How's it going? This is Immigration Attorney Moumita. Thank you for joining me live. I am here to talk to you about some of the most pressing immigration questions you may have regarding what is going to happen to your green card, what is happening to you if you're married to a U.S. citizen and your marriage is not working out. Now, today, the specific question that I will talk about for all of you today is if you are someone who has already filed your I-751 in order to get your 10-year green card, but now it looks like divorce is on the horizon and you're not sure what to do. Should you wait to, should you stay in the marriage in order to get your 10-year green card? Or should you go ahead and sign those divorce papers and move on with your life? And additionally, if you have been suffering in your marriage, which you did not understand what was happening, but now you understand that what you are going through was extreme cruelty, that it was manipulation, that it was gaslighting, and now you are learning that you may be eligible to file for a waiver for extreme cruelty. What should you do? This might be the most confusing time in your life, and you may be presented with these two options and confused about what is the best road for you to take. So I'm going to discuss that right now, but before I do that any further, my name is Moumita Rahman, and I am an immigration attorney. I'm based in New York, but I help immigrants all over the US. So no matter where you are, whether you are in California or Texas or Idaho, wherever you are, feel free to give me a call at 212-248-7907 to book an appointment so that we can go over your legal options and find out what is the best way forward for you in your case. So let's go ahead and talk about this question of the day, which is if you have filed your I-751 and now you are considering divorce and you're also finding out that you're eligible for your extreme cruelty and battery waiver, what is the best option for you? Now, here's the thing. When you file your I-751 jointly with your spouse and things take the wrong turn, things are not going out so well, or maybe even things were not really going so well before, and it's like you had to basically, fight tooth and nail to get documents in order to file this application with your spouse, and now you just cannot hold it any longer. You may be needing to file for something called an amendment to your case. Now, you may be eligible to file for either a waiver due to divorce or a waiver due to extreme cruelty and battery. But there are a few differences that you must keep in mind. Number one, you cannot file for the waiver for the divorce, basically for your marriage ending in divorce, unless you have an actual termination of that marriage, which means that you must have a divorce decree. If you don't have a divorce decree, then if you file an amendment for this application due to divorce, but you don't have that decree, then you will be issued a request for evidence, which you must respond to and answer within 87 days in order to show that you're eligible for this waiver. If you're not eligible for it, then you may end up getting your case denied. So I do not usually recommend that people file for this divorce waiver unless they have already terminated their marriage and they have the copy of the divorce judgment. Now, what happens though if you are just struggling to hold on and you're struggling to stay in this marriage, you're suffering on the daily, you keep getting gaslighted by your spouse, and you just can't take it any longer? Do you have to wait until you get divorced in order to file? And the answer is no. If you qualify for a waiver due to extreme cruelty and battery, then you can file that at any time during your marriage. You can file that at any time, whether your card is expired, whether it's about to expire, whether you just got your 2-year green card, you can file for the waiver for extreme cruelty at any time. And you do not need to get divorced or even have started the divorce process in order to file for this waiver. In addition, you may still be able to file even if you are living with your spouse, because just because you are living with your spouse does not mean that they're going to help you with your 10-year green card application. If you do find yourself in the situation, feel free to give me a call, 212-248-7907. We may be able to file this waiver even if you have already filed a joint application, but the key is that you must take action at your earliest opportunity, because if you wait until it's too late, you may be stuck going to the interview alone and not having a waiver ready, and your case may end up getting denied. So the best course of action is always to be proactive and to find out what your legal options are right now, okay? 212-248-7907, and thank you. Hello to everyone. So that's my question of the day, and now I'm going to go ahead and answer some questions. I have a question from A. Bhatia who's saying, I filed an I-751 back in October 2018. My online status is saying since April 2020, it's ready for scheduling an interview. How long will it take? How much longer will it take? And the answer to this question really is it depends. It depends on your local fields office. It depends on how backed up they are with interviews. And for certain, they are prioritizing citizenship interviews right now, and then marriage green card cases. And the I-751 will follow later, because I do not believe that they're prioritizing it as much, for the simple fact that, you do receive a letter of extension. And a fun thing to keep in mind is that even if your letter of extension expires for the I-751, as long as your case does not have a denial in it, you are still considered a resident. And even then, a little secret that people don't always understand is that even if USCIS denies your I-751 application, you still retain residency until a judge in immigration court says otherwise. Okay. All right. Phineas John is saying, my dad filed for me, but I missed my interview because of change of address. He reapplied. How long should I wait for an interview? From Phineas. Phineas, I'm so sorry to hear that you missed your interview. However, you probably will be waiting about the same amount of time as before. Maybe if you got a successful reschedule done, then you might have to wait less time. Carlos Rivera, thank you so much. Carlos is saying, it's always good to listen to your valuable and supportive information. Thank you. I really enjoy coming on here and sharing whatever I can. I know that immigration is actually very complicated. It can be very scary. And people are always hearing X, Y, and Z all over the place. And of course, it is a matter of opinion for a lot of attorneys as well. But I'm happy to say, and I'm happy to share my 11 years of knowledge with all of you. All right. I actually have another question from Carlos. Hi, Carlos. Okay, after receiving a VAWA approval notice letter, how long does it take to get an approved I-485? Both the I-360 and the I-485 were submitted concurrently. Now, the answer to this, Carlos, is also it depends. It depends on, number one, if your local field office is going to give you an interview. It also depends on, how long any person for your local field office is waiting to get an interview scheduled. For example, in New York, we may be waiting up to a year for an interview, and some other places that are less busy, like let's say Mount Laurel, New Jersey, might be waiting only, less than 6 months for an interview. So it depends, but congratulations on getting your VAWA approved, Carlos. Hopefully you don't wait too much longer to get that wonderful 10-year card in your hands. Okay, all right. Let's see what questions I have on Instagram, and thank you to everyone for joining me. I have a question from Arbeen, who's saying, can I make an appointment in Zoom with you? Arbeen, yes, you can call. So make an appointment with me. You just have to call 212-248-7907 to make an appointment. I'm only doing phone and video appointments so I can accommodate all the people who want to speak with me. And it is no problem. We do not need to be face-to-face in person. I'm perfectly well and able to understand exactly how I can help just by speaking. And of course, you can also send us some documents to review prior to your appointment. Now, if you have 200 pages of documents, I won't be able to review them, but there are a few key things that I like to see as part of any consultation. Number one is if you have ever filed anything with immigration in the past, I like to see the decision letters. I like to see a copy of the application if you have it. Number two, if you have ever been arrested for anything, I certainly would like to see the dispositions of those arrests and find out what the final conviction was. And number three, if you have ever been in immigration court, I definitely would like to see your A number as well as anything that you've gotten from the judge. All right. See what other questions I have. When will we finally get some movement on family-based green cards? From Augustine. Augustine, I'm not 100% sure. Family-based green cards are seeing a little bit less of a priority because they are trying to catch up on immediate relatives first. As a resident for 2 years, how long can I apply for citizenship from plus Fort Martin? Fort Martin. All right, if you are a resident, it depends. It depends on, first of all, how did you obtain your residency? If you obtain your residency through marriage to a U.S. citizen, then you may be eligible to file for your citizenship within about 3 years. But the two conditions are this. Number one, you must stay married and also stay living with your U.S. citizen spouse, or you need to have approved your residency through VAWA, or have an extreme cruelty and battery waiver approved for your I-751. If none of these apply, and let's say you got divorced or you got your green card through someone else, then you have to wait 5 years. And that is the typical amount of time. It's either 3 years or 5 years. Naeem, thank you so much. I got my green card from Manoj. I got my green card and travel documents. I travel abroad and my case was denied, but I still have a valid, is it good to travel back, from Manoj Reddy. Manoj Reddy, if you and anyone else who gets a travel document and while they're abroad, their case inside gets denied. Well, if your case inside the US gets denied while you're outside and your I-131 is attached to that case that got denied, then you're probably going to have a little bit of a difficulty in re-entering, but you might be able to seek parole when you come in. From Obeng is asking, which status can a person who's in asylum proceedings being terminated by the immigration judge? Obeng, and anyone else who is in removal proceedings, in order to get your case administratively closed, you usually have to show to the judge that you have some other collateral relief outside that is eminent, that you're qualified for, and that it's likely. These are usually the reasons, and they can be on the basis of having an I-130 approved, on having a child who can petition for you. It really depends on your case. But typically, in order to get your case admin closed by an immigration judge, you must show that there is something that is waiting for you outside of court. And sometimes you may not even have to show that. If the judge doesn't think that you're like a risk to the community, they may even be able to close. It never hurts to try. Okay, time for one last question. Janitsi is asking, do you deal with immigrants who are incarcerated? Janitsi, at this moment, I am not doing, I do not take any cases for persons who are currently detained. However, if you or a family member has a loved one who is being detained in immigration detention, you can still call my office and we will refer you to somebody who is dealing with these cases. For these cases, it is best to deal with an attorney who knows those courts and who is able to go visit your relative in court. So I am not taking those cases, but do give us a call and I'll be happy to refer you to some of the excellent attorneys that I know. Is there a way for immigrants who have double entry to fixed status? From Cynthia Garcia. Cynthia, so I think you were talking about something called the permanent bar. If you know that you have the permanent bar, there are mainly 3 types of cases where you may be able to fix this inside the US, and these include VAWA, which is for either a parent of a US citizen child who has been subjecting the parent to extreme cruelty or battery, or a US citizen spouse who has also done the same thing, if there's a connection between the abuse and the entry or exit. Number 2 is the T visa, which is for victims of labor trafficking or sex trafficking. And the 3rd is the U visa, which is for victims of crime. I'd be happy to go over your options. Cynthia, give us a call, 212-248-7907. Manish, hello. All right, so one last question. James Edwards saying, I have an appointment with you in 9 days. James, I'm looking forward to talking with you. All right, actually, that's it. This is all the time that I have for today, but please make sure you keep on your notifications so you can join me tomorrow when I come live. All right, everyone have a wonderful day.